Today we're going to talk about common interest communities. We've been already talking about them without naming them in the context of real covenants and equitable servitudes. But right now we're going to do a deeper dive into what a common interest community actually is, and then talk about the way that covenants and easements are used in this context to establish private land use controls. What you see here are fairly typical representations of a common interest community. On the left in yellow, you see a plat drawing that takes a single parcel of land that has been subdivided into multiple individual parcels. And if you notice on the lower left, there's an area that is designated future development. That is an area that has not yet been subdivided, but the developer probably intends for it to be a subsequent section of this same development. And then on the right, what you see is a black and white aerial image of what the plots actually look like once the houses are built. So how this works is a developer will buy a large tract of land with the idea of breaking it into smaller portions, smaller plots, individual plots of land to build individual houses. And the subdivision is that process of taking a single lot and converting it into multiple individual tax lots that are described by meets and bounds descriptions and have separate deeds. So the subdivision plan will depict the relative location of not only the newly proposed land units, as you can see here, but also the roads, the access points for ingress and egress into the development, and the utility entrance points. So this is an extensively regulated process. The subdivision plan, the plat, before anything is built, will be recorded, and it depicts the layout of the lands, the subsurface utilities, and the access points. And each of the individual deeds will refer back to this subdivision plan. So once the lots are laid out and the streets are designated and the utility routes are planned, then the individual parcels are created with their own individual legal descriptions. And to coordinate the placement of easements, the placement of utilities and access points, some of these lands will be burdened with easements for the benefit of the community as a whole. Now, not every subdivision is a common interest community. To create a common interest community, there has to be a declaration announcing that this is going to be a common interest community. And that declaration will be recorded with the subdivision plat. And again, each of the individual deeds will refer back to this declaration. The declaration, as you can see, will announce the formation of a homeowners association and will specify its powers and procedures, and then will announce whatever covenants, conditions, and restrictions that will either be real covenants or equitable servitudes on each of the properties. That can include an assessment, an obligation that each unit owner pay money to the homeowners association on a monthly or annual basis, and these sort of covenants, conditions, and restrictions can go well beyond what the local zoning law would require. So in addition to having to comply with whatever the local law requires, the declaration will require that the owners of the subdivided units abide by the terms of the declaration. The easements that are on the statements in the filed subdivision map, and these requirements in this declaration could be as mundane as, say, not permitting chicken coops in the subdivision, to being as complex as requiring specific types of architecture. And this homeowners association created by the declaration acts in a sense as a private government. It can enforce the restrictions and can take any actions that are allowed by the bylaws that are created by the homeowners association. There are three basic types of common interest communities. There are condominiums, there are cooperatives, and then there are communities with a homeowners association that are neither condominium or cooperative. And we will talk about all three in um, in turn. And this kind of private land use control is probably the most flexible in terms of how it controls uses of land. Cooperative, condo, and homeowner association rules are easier to change than covenants and easements. The fact of them is recorded, right? The fact that there are covenants, easements, and restrictions is recorded. But the text of the various rules is not. The text of the rules can be changed by a majority vote of the HOA board, the condo board, or the co-op board. And then that change will be binding on the owners of the subunits. And these rules are rooted in what we're going to talk about in the next video, nuisance. Because these rules are viewed to be an agreement about what constitutes quiet enjoyment. And because they are considered voluntary, which I hope you can hear the air quotes around voluntary, because right, one is opting to purchase into this community. Nobody's obliged to live in a community with an HOA or to live in a condo or a co-op, right? That is a choice that a homeowner makes, and therefore it is considered a voluntary agreement to abide by these covenants and restrictions. They can be very intrusive. There could be rules about noise. Now, mind you, there's also public law about noise, but this can be much more intrusive rule about noise, including you have to carpet your floors if noise is a problem. It can be rules about smoking, rules about pets, including size and breed restrictions, rules about whether you can use air conditioners, what kind of air conditioners you might have to use, whether you have to have Energy Star appliances, the kinds of trees you can have in your yard, whether there can be cars in the driveway, whether there can be flags, whether you can have an RV, etc. Right? All of those would not probably stand as zoning requirements or as municipal nuisance ordinances, but are perfectly valid when they are rules of a homeowners association, a cooperative, or a condominium. So that brings us to the Lakeside Villages case, and I thought you might like to see what it looks like. It is a 530-unit condo association in California near Culver City. And just to give you a anchor for what we're talking about in terms of level of affluence, the one bedrooms last time I looked sold for around $600,000. So the background to the Narstead versus Lakeside condominium case is the California Civil Code, right? What is the law in the jurisdiction is the first question before you get to what do the CCRs require. So the California Civil Code requires that covenants and restrictions in the declaration, right, of that subdivision that we plot that we were talking about, that is right, a recorded declaration, shall be enforceable equitable servitudes unless unreasonable, and shall ensure to the benefit and bind all owners of separate interests in the development. And that these servitudes can be enforced by the association or by an owner of a separate interest. And also, right, as a disincentive to litigation, in an effort to enforce the CCRs, right, a prevailing party is entitled to attorney's costs, which is not the norm in American litigation. Right? So that's the background of this case. CCRs are enforceable unless unreasonable. So that brings us to the case I asked you to read, Narstead versus Lakeside Condominiums, right? Mrs. Narstead had a unit in the condo, and she is in court because she doesn't want the CCRs to apply to her. Right? She has cats. The condo association has banned the pets, and she thinks that the board could not show that the rule was rational as applied to her because her cats were indoor cats. And so her position is that background law that CCRs are enforceable unless unreasonable should mean that the board has to demonstrate that the rules are reasonable before they can apply them. Now, the lower court says, right, that the standard should be an individualized standard, right, and that the court inquiry should be whether a CCR is unreasonable in each particular homeowner's case. Right? The appellate court rejects that. Right? The court rejected the idea that the reasonableness of CCRs was an individualized showing based on individual circumstances, and also rejected the idea that the HOA had to demonstrate reasonableness. Instead, the court said that the burden of proof in the statute was clearly on somebody objecting to the CCR to show that the rule was unreasonable, and that showing was not a contextualized individual showing, but that the rule was unreasonable across the board. So the fact that her cats were indoor cats was not relevant to a demonstration of whether or not a restriction against pets, period, would be unreasonable. Now, what about the argument that this controls activity wholly within the owner's interior space and doesn't invade either other units or the common area? So why should CCRs be able to control what a person does inside their unit? Why isn't that true? Why isn't that too intrusive? The Supreme Court responds to that directly and says that CCRs are entitled to a very strong presumption of validity, and the court, in figuring out whether or not a CCR is unreasonable, and again, right, this is going to be the burden of proof is on somebody challenging the CCR. The standard will be whether the harm caused by the restriction is so disproportionate to the benefit. And the reason they adopt this standard is because they want to discourage lawsuits. As we said, this particular condo association has 560 units. They don't want to see 560 lawsuits, and they don't want to have to decide whether your cats are okay and your cats are not, because your cats might go outside and wear a bell while your cats stay inside. Right? The courts don't want to be in the business of having to wade into the minutia of homeowners associations. And courts want to promote stability and predictability, and do not want to put homeowners associations in the position of having to deplete common funds, right, that are paid by those dues that maybe are required by the declaration to litigate in defense of CCRs. Because the cost to litigate comes from the residents that are subject to the CCRs. So using that overarching perspective of these CCRs are entitled to a strong presumption of validity and wanting to discourage litigation and focusing on whether or not the CCRs are unreasonable per se rather than as applied in individual context, the court said it is not unreasonable to say that pets are not allowed in units. Because yes, Ms. Narstead claims that she keeps her cats inside, but what if they get out? And even even if they don't get out, certainly the possibility of dander on her shoes carrying into the common space might affect other people. So what does this mean, sort of in big terms, right? This slide just summarizes what I just said, really, that CCRs are entitled to a very strong presumption of validity, and the petitioner has the burden of proving unreasonableness. But notice this framing. What constitutes interference with peaceful and quiet enjoyment of property is how this is framed. Right? This is basically the same covenant of quiet enjoyment that we saw in the landlord-tenant context and in the warranty deed. It comes to us from nuisance, the right to be freed from nuisance. So here, Narstedt claims to have no knowledge of the CCRs when she purchased, because she moved in with her cats and she said, I wouldn't have purchased, I wouldn't have moved in if I'd known about them. So why isn't she a bona fide purchaser for value who takes free of the covenant? The answer is that this is recorded, right? The declaration was recorded with the unit, and maybe the specific no pet requirement wasn't, but the fact of an HOA and the fact of CCRs was recorded, which put a burden on her to investigate and find out what rules she would be subject to. And the court here says, right, we are of the view that our social fabric is best preserved if courts uphold and enforce solemn written instruments that embody the expectations of the parties. So again, they're emphasizing this is a voluntary relationship that Ms. Narstedt has entered into, and the fact that she didn't do her due diligence before she purchased, when it was eminently discoverable that there was a pet restriction, means that she cannot take as a bona fide purchaser without value, and her subsequent challenge to the reasonableness of these CCRs loses. So you got to think about, like, how intrusive could these restrictions be? The court here is upholding a no pet restriction, but what if instead the CCR had said only college graduates can live here? Now that is, right, wholly unrelated to land. It is solely about who lives in the buildings. I think it would be very hard to defend that. Or what about nobody can have a television? Or you have to wear natural fibers, right? You can see, I think, if you look, how intrusive CCRs could be. And at some point, courts will surely draw a line and say that is too far away from anything having to do with the land and with nuisance, right? With the idea of quiet enjoyment of the land. Now, you certainly could have a noise restriction that limited how loud televisions could be, but I think it would be very difficult to say that it was a legitimate CCR even with the strong presumption of validity, to say that nobody may watch television. So the reaction to this case was fierce and pretty furious. The California legislature responded by outlawing pet prohibitions, right? And you can see here an amendment to the Civil Code. No governing documents shall prohibit the owner of a separate interest within a common interest development from keeping at least one pet, blah, 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 blah. It's subject to reasonable rules and regulations. And so I show you this in part just so you know what the aftermath was, but also because I wanted you to understand the relationship between the background laws of the state and the CCRs of the common interest community, right? The laws of the state set the contours within which HOA rules can exist. And HOA rules must conform with the laws of the state. So if the state says that no governing documents can prohibit somebody from keeping a pet, one pet, then any HOA rule to the contrary would be void. And in fact, in 2016, Lakeside Condos updated their pet policy to allow 2 cats or dogs in each unit. So a further update, controversy at Lakeside condominiums did not end with the pet issue. In spring 2021, there was a vote to recall the board. And from Facebook, it seems that there were allegations of cronyism and self-dealing in condo contracts and issues over whether residents could attend the board meeting. And so, right, one of the concerns that people were raising in this particular condo association was whether or not you could store things on the patio. And you can see here people were um, speaking out in support of the rule you couldn't store things on the patio because people were storing junk and it didn't look nice. So obviously what can be considered junky is subjective, as this person pointed out. And this is just to give you a sense of how intrusive the rules can be. And I just want to focus in on where Justice Arabian flagged this issue, saying, right, whether someone can have a doormat or hang a towel on the patio rail. He says that's exactly the kind of thing that an HOA should be focused on. And then, of course, there are the great wind chime, bird feeder, drying lines battles. So the bans against clotheslines actually in HOAs actually gave right to a nationwide right to dry movement, seeking to amend state laws, just like we saw for the pets in California, to invalidate HOA rules against clotheslines. And so 20 states now have laws overriding HOA bans on drying lines. And if you want to look for the right to dry, if you're interested in that, you can look for the right to dry online and see how that is progressing. So I can't move away from this without sharing my absolute favorite photo in the world with you. So this is a photo of an apartment at the Drew Hamilton Houses on Adam Clayton Powell Boulevard. And NYCHA does allow residents to have one pet, but it is a pet that must not weigh more than 40 pounds. And as you can see here, somebody had a Siberian tiger. This is Ming Ming. And this is a New York Police Department emergency service employee rappelling down the side of the building with a shotgun, with a dart gun, trying to dart Ming Ming to remove her from the apartment. There's a whole saga there. It's fascinating. I'm not going to waste your time with it right now, but I just felt the need to share this with you. Obviously, this was a breach of the CCR in the apartment. So I wanted to show you the New York law, which is in many ways very similar to the California law for CCRs. You can see that each unit owner shall strictly comply with the bylaws and with rules, regulations, resolutions, and decisions adopted pursuant thereto. And failure to comply gives rise to an action for damages and for injunctive relief, or for both. And the board, on behalf of unit owners, can bring such a lawsuit. So the board of the condo, the board of the HOA, or the board of the co-op. And this is pretty common. You'll see most states have a rule like this, saying that CCRs are enforceable and that anyone who is found not in compliance with them can be liable for damages or injunctive relief. So I just pulled some standard CCRs from a neighborhood, right? Because what we're going to talk about is, I started by dividing this up into HOAs, condos, and co-ops. So typically, subdivision communities that are otherwise single-family homes held in fee simple can also have an HOA with CCRs. And some of the typical CCRs in those kinds of communities are architectural, right? What kind of roofing material was allowed, what kind of driveways people can have, and what kind of vehicles can be parked in driveways, whether vehicles can be parked on the streets, etc. Now, could be something that applies in a neighborhood that is otherwise single-family homes that are held in fee simple, because when the subdivision was created, a declaration was filed with that subdivision plat, creating a homeowners association and giving it the power to make CCRs. Condominiums are different. In a condominium, each unit from the paint inward is owned in fee simple by an individual owner. But the exterior walls, the land, and the common areas are owned collectively by all of the residents as tenants in common. A condo association will have a board, and the board has the power to levy assessments for improvements to the common areas or repairs to the common areas, and can make rules in accordance with its bylaws. Typically, the board does not interfere with the sale of condominiums. The board may and often does have a right of first refusal for the sale of any condominium, but otherwise an owner can sell the unit freely. This is a big difference between condominiums and co-ops that we will talk about in a minute. So if you think about CUNY School of Law, CUNY is in a condominium relationship with Citibank. We own the interior of our 6 floors, and the floors above us are owned of the interior by Citibank. And then there's a condo association that controls the elevator, the roof, and the mechanical systems. So cooperatives are probably the hardest of the common interest communities to understand, because a cooperative apartment system is a corporation, and the residents are shareholders of the corporation and tenants of the corporation, because by purchasing shares in the corporation, each shareholder is given a proprietary lease that is attached to those shares that gives the shareholder the right to live in a particular apartment. So the board, because it is the corporate board of the entity that owns the apartment, has more power than a condo board does. And typically the rules in a cooperative are more restrictive and more pervasive than in a condo. The key difference is that nobody can sell a cooperative apartment to a new purchaser without board approval. And the board can, and frequently does, place restrictions on subleasing of the apartments. And so let's talk for a minute about this board, the Cooperative Apartment Board, because it is just like the board of any corporation like McDonald's or Citigroup, right? It is a corporate board that is formed under the corporate laws of the state and is governed by the general corporate law, including the business judgment rule. So by purchasing in a cooperative or in a condo to a lesser extent, but the owner consents to be governed by the board. And in a condo, right, the board has less authority, and in general needs the approval of the shareholders. Of the association members before it can make significant financial decisions. By contrast, a co-op board runs the day-to-day affairs of the corporation and has broad powers in financial decision-making. And of course, it can promulgate rules regarding pets and parking and all kinds of things. Now, the business judgment rule prohibits inquiry into decisions taken in good faith and the exercise of honest judgment in the lawful and legitimate furtherance of corporate purposes. So Board members have a fiduciary duty to act in the interest of the corporation, and so long as the corporation's directors have not breached their fiduciary obligation, the exercise of their powers is not questioned in court, although the results show what they did might be unwise or inexpedient. So there's tremendous deference to the co-op board, just like any other corporate board, in making decisions about how the corporation is going to spend its money and about what the rules of the corporation are going to be. Okay, so let's sum up in terms of the big picture. So, question number one, does this agreement that you're looking at, that has been recorded with land, give someone the right to use the land of another? If so, it's probably an easement. Does this agreement try to prevent someone from using their own land in a certain fashion? It could be an easement, it could be a negative easement, but probably it's an attempt to make a real covenant. So the next question you need to ask is, if so, are these people who can make a real covenant? Is land being subdivided when the covenant's attached? Because as we talked about, the only moment that you can make a real covenant is when there is a mutual interest and successive interest in land. So you need land to be divided in some fashion in order to make a real covenant. You have to have a single owner who is dividing up land. That's the moment where you can make a real covenant. If the answer to question number 3 is no, right, that the land is not being subdivided when the covenant's attached, then probably whoever is trying to do it cannot make a real covenant. And then the question becomes, can this be an equitable servitude? And the critical questions for whether or not something can be enforced as an equitable servitude is there notice, and does it touch and concern land? And with that, I think I'm going to stop, and the next video will talk about nuisance.